How is property divided after a marriage annulment? Imagine a marriage that never really happened in the eyes of the law. That's what an annulment does. But what about the property? How is it handled? Well, it's quite different from a divorce. Since an annulment treats the marriage as if it never existed, there usually isn't a need to split assets like in a divorce. Instead, courts look at who owned what before the marriage or what was acquired separately. If property was bought before the marriage or kept separate, it generally stays with the original owner. For example, if one person owned a house before tying the knot, that house remains theirs after the annulment. If property was bought during the marriage but was jointly owned or mixed with shared funds, courts might consider who contributed what and decide based on fairness. Sometimes, the parties agree to buy out each other's interest or sell assets and split the proceeds. This is often done through negotiations, not a set legal rule. Unlike divorce, annulment usually doesn't involve spousal support or dividing property equally, because the marriage is considered never to have existed. However, some jurisdictions like Indiana requiring annulment proceedings to follow the same rules as divorce cases when it comes to property and children. That means courts can still decide who gets what based on contributions, ownership, and financial circumstances. If property was acquired before the marriage or separately, it's usually considered separate property and returned to that person. When property was acquired jointly or mixed during the annulled marriage, courts may look at fairness and agreements between the parties. It's always a good idea to negotiate and reach an agreement to avoid lengthy court battles. Getting legal advice is important, especially if there are significant assets or children involved. Overall, property division after annulment aims to restore each person to their financial position before marriage, since the law treats the marriage as if it never happened. Courts will examine ownership and contributions, sometimes applying procedures similar to those used in divorce cases, but always within the context that the marriage was void from the start.